This is my email. You can try to reach me there. I will honestly say I'm in the middle of a bankruptcy and a lawsuit, so I'm not really responding to email all that much these days. But if you say it's important or you have a quick question, feel free to send it off and I will try to get back to you. I have to actually read you these disclaimers according to the California Bar Association. If this presentation were legal advice, it would be followed by a bill. Standard lawyer joke. No attorney-client relationship is formed by the fact that I'm giving you this talk. And everything contained herein is for educational purposes only. It is Halloween, and I was going to try to wear my Deadpool costume. And after I put this thing on, I realized there is no way you can actually see, and I have no idea how Ryan Reynolds did this for hours and hours and hours. So, sorry, Deadpool. Oh, wait, I have a picture. I'm having trouble with PowerPoint again. Did I mention I'm not a PowerPoint person? I should have Kate do this. I can click in the middle, thank you. This is Deadpool. I thought Deadpool was appropriate because we're gonna talk about insurance. Insurance is all about pools. That was my connection. I put the costume on this morning. Oh my God, it's hot. And I can't see out of it. So, sorry, I'm not in Halloween costume. Sorry you don't have a female version of the Deadpool. So let's talk about risk and cyber insurance. And also, one other slight disclaimer, as I was re-preparing for this, I realized that I have stacks and stacks of paper. There's tons of actual minute details and differentiations in this area of insurance and law. So I'm gonna actually have to refer to notes because they wouldn't all fit on the slides. And if I get something wrong, again, full disclaimer, no attorney-client privilege created. I actually was mostly a cybersecurity professional, even though I got my JD back in 1995. I didn't go back to, it was always like my side hustle, right? Okay, you're the IDS biz dev person. Hey, can you look at the contract? But for the last 5 years, I actually have been doing law. And this area of cyber insurance is one that even I wouldn't touch. So most of us have a concept of insurance, right? And the whole point of insurance is to identify the risks. That's like step number one. It's super important. That's where everybody who is in software development, compliance, risk management needs to participate and assist your client or your company in understanding the risk. And then on the insurance side, we have some methodologies that we can attempt to use to manage that risk. And they generally fall into the 4 categories. We can accept the risk. That's, again, where it's incredibly important to try to have actual good data, facts, and figures to assess that risk. So if you're going to accept it, you want to know what it's likely going to cost you. You can try to avoid it, putting in a mitigation or a remediation. You can try to mitigate the risk through some internal processes, controls, or you can try to transfer it. So insurance falls in the area of mitigation and transfer. That's what we're trying to do with our insurance coverage. We're going to try to mitigate and transfer the risk. Now, there's also, just like cybersecurity, the insurance world is full of its own lexicon. And it is, even to someone who actually knows how to read legal documents, it is highly confusing. The notion of a first-party risk versus a third-party risk is incredibly nuanced and easy to confuse. My shorthand for it, and we're going to go into it in more detail, is first-party risks are things that happen to you because of you, and third-party risks are things that happen to others because of you. So it's all about, what happens to us, but that nuance around because of you can be very subtle, because of you could mean you chose this vendor instead of that vendor. Oh my gosh, can you imagine if you're in retail and you have a PAX point of sale system right now with the FBI knocking on your door? Okay, that's my nightmare. FBI knocking on my door, which did happen to me a few times at Force Point, is actually my biggest nightmare. They're nice guys, but you really don't want them knocking on your door. So there are some risks under insurance that you cannot waive, transfer, mitigate, or avoid. So it's really important to understand those and to know that this is something you're going to have to deal with internally, as opposed to try to get your cyber insurance provider or your vendors to help you with. And the first one and this is actually, we're going to go into a lot of detail about this. It's a very esoteric area of law called work product privilege and the failure to create the proper control group. So if you ever hear work product or control group, my advice is to leave immediately, because you're about to go down a rabbit hole and you may end up, that 24 hours that Dan was talking about, it's going to turn into 28 hours in a day you're going to be working. And the second area of risk that can be transferred is remediation. You can't say, but if I make a mistake, even if it's a genuine mistake, you, cyber insurance company, have to cover my remediation costs, except in a very rare exception. The insurance company is only typically obligated, it's a contract principle, to put you in the position that you would have been before the incident. So they're not going to help pay for all the remediation costs that your forensics team might turn up as desirable. So for most of us in software development or in compliance or risk management, that means the cost associated with fixing a vulnerability is on you. And the cost associated with figuring out what that vulnerability is might also be on you. So it's important if you're trying to help your CISO or your general manager understand where you think the line is in your risk level. It's important to really realize some of these costs are always going to be on us. And that's easy to forget when you're talking to insurance people. There's one tiny little exception, which is that your cyber insurance might cover replacement of physical hardware if it's actually damaged by an attack. And believe it or not, this actually does happen. It's not, in some of the more sophisticated attacks, we've certainly seen where people figure out what your wide area nexus access controller is, and they'll try to either overrun it or damage it. I've got a case actually right now where that actually probably happened. And this was one area we were able to go back to them and say, no, you need to pay to replace that. But it's something we easily forget, but it can be part of your coverage. Okay, now here we get into the long, incredibly boring parts of cyber insurance, but they're also kind of important to understand. So I have this giant list of them here, and I'm gonna just give you a couple of highlights. And I think I put these in the notes in the slides so you can refer back to them. And if not, somebody will remind me and I'll put them in the notes in the slides. I'll refer back to them. So we have vendor acquisition. Now, vendor acquisition is not the third-party risk that you might think of under your PCI DSS. It's not doing third-party assessments or requesting risk assessments from the vendors you're going to hire. This is hiring the people that are going to help you if you have an incident. So that is an example of a cost that is typically covered under your cyber insurance policy. Legal representation for regulators. And there is a big nuance right now about PCI. How many people here deal with PCI? Yeah, there's a big nuance right now with PCI because most cyber insurance covers regulatory, the representation with regulatory committees and fines. So that would be HIPAA is a clear example. If the OCR, the Office of Civil Rights, who's actually the enforcement body for HIPAA, comes knocking on your door and you need to hire a HIPAA specific attorney, and then maybe they fine you. That is an example of a regulatory service and a regulatory fee you may have. There's an argument right now around PCI because PCI is technically not a government regulatory body. It is a vendor association. There's a recent case where the PCI fines, and they do call them fines, Visa calls them fines, where they actually went back and looked at the merchant agreement and they decided they were assessments, not fines, not covered. So if you deal with PCI, very important that you let the folks know who are dealing with their cyber insurance to carefully look at their merchant agreements and make sure that they're being tagged as fees, not assessments. And I don't know, who knows what's going to happen there. I feel sorry for the people who pay insurance and think they're covered and then end up having to pay twice, but that's the way the law works. It's constantly moving. It's a marathon, not a sprint. So specific regulatory fines, like we're all wondering what's going to happen with the latest ransomware, with Colonial Pipeline. They're certainly going to be assessed, probably FERC, a Federal Regulatory Energy Committee, and NERC, nuclear, whatever they are. They're probably certainly going to be fined under NERC SIP. And we're going to look and we're waiting to see whether that is actually covered under their cyber insurance. That'll be a very interesting one. Notification costs, if you have a data breach or if you have a contractual obligation for notifying, you can typically get those. That's an area of coverage that you can elect. PR costs. You can actually get a crisis PR vendor and they will pay for the cost of that. Then there's the costs of credit monitoring services. It's become fairly commodity now, but almost all of that is usually covered under your cyber insurance. Incident response costs, that's again, not your internal IR. Your internal IR is on you. Your internal project and reports done with your human beings are on you. But if you need to hire outside IR, you can have those IR costs covered. We talked about damages to physical assets. Ransomware payouts, we're going to talk about ransomware payouts a little bit later in a little more detail because again, it is whenever here's a fundamental principle of insurance. It's right back to Berkshire Hathaway, right? You want to take in more than you pay out. Well, what's gone up crazy, insane, unpredictable is ransomware is one of those. And it's been a lot associated with the pandemic, associated with work from home, new attack surfaces being opened, people under more stress, they're maybe not being as careful and paying as much attention, kids having access to your work computers, all sorts of reasons why it's gone up. Because it's going up so much, what are the insurance companies looking to do? They're looking to avoid. So they're pulling out the fine details associated with ransomware payments and looking for all sorts of ways to avoid paying on them. And we're going to go through a couple of those examples later in the talk. And then lost income. So these are just kinds of areas of coverage that you can look for in your cyber insurance. There's also different policy categories under which these might fall. So you might think, for example, if you've got general business insurance and you have business disruption insurance, that, oh, I don't need lost income under my cybersecurity policy. You would be wrong. Because the way cyber insurance works is there's underwriting and there's policies and then there's exclusions and there's caps and limits and all sorts of things. And you have to be very, very careful about what is covered under what. And again, because of the costs associated with this, more and more we're seeing insurance companies actually fighting to try to not pay. This actually also happened in the very beginning. Oh, I said I wasn't going to talk about ACH wire fraud. I'm going to say it anyway. In the very beginning when ACH wire fraud first started happening, I did. Okay, wait. Here we go. Somebody gets a chocolate bar. So Kate won't eat them. It's got sugar in it. So there's always a fight. Whenever there's a new level of payout anticipated, you can expect that your cyber insurance company is going to fight. And this is just, we also in the industry, when, 20 years ago, there were maybe 3 organizations that you could get cyber insurance from, Marsh, AIG, and one other. Now there's probably about 60 vendors out there that are writing policies. A lot of the big policies are still underwritten by, European reinsurance risk category companies, but anytime there's that much competition in there, it gets very fragmented in terms of the actual underwriting, and it's difficult to understand what you actually have. So let's talk a little bit about network security insurance specifically, and this is near and dear to my heart because I just got my first malpractice insurance policy, and 90% of the policy language was all around network security. They even asked you specifically if you used an Exchange server. I'm like, well, I got lawyers. Yeah, maybe they still do use Exchange servers, on-prem Exchange servers. Lawyers in government, that's probably the only place those still exist. So I actually tried to read it. And remember, I am a professional. I actually understand cybersecurity. And I got about halfway through it and decided that this was just, I wasn't going to buy it. And so it wasn't worth my time. I spent an hour and a half trying to read it, and I decided it wasn't worth my time. This is an area where the lingo and the specific underwriting clauses can be highly confusing. So when we said in the very beginning, there's first-party coverage. First-party coverage is for causes and events and actions that you do to yourself. And then there is third-party coverage. So third-party coverage is when you think that you might need to protect someone that your causes, actions might impact. So if you are a billing solutions provider, for example, and you send out a lot of messages and you accidentally send malware to one of your customers, that would be an example of a third-party risk that would be paid for under your third-party coverage. And this is an area of growing concern, especially as on the regulatory side, as people are looking at DSS and the CSA STAR, all looking at how do we require third-party risk assessments from our vendors. Then our third parties are actually thinking potentially of coming back to us if we cause an accident or an event to harm their system. And you can get all sorts of coverage there. Again, with that PCI DSS, read the language very carefully, because that is going to be coverage for you causing a problem somewhere else. It may not cover your own actual loss. Breach response is another area there's been a lot of talk and a lot of coverage about lately. It used to be fairly reasonably priced, but the underwriting is getting much more sophisticated now. So they're actually going to go back and look at, what type of data do you have? Who are your third parties? It does help if you have GDPR experience and you've done a true privacy assessment and you can show some actual data and some actual policies and procedures around that, you might be able to get a lower cost or a lower premium, but it's still a very nascent area of law, and then the coverage is highly variable, except the notification and the third-party monitoring. Those are pretty standard features now, and you can get them at fairly reasonable prices. And then there's like the first-party coverages that are the more esoteric components. Are you being extorted? And ransomware, by the way, is now sometimes being called out expressly separately from network extortion. So network extortion would be a DDoS, the old DDoS attacks, right? You're going to have a big game in Vegas. We're going to DDoS your betting site. That would be considered a network extortion. Ransomware, because there's no pre-notification, isn't technically extortion because it comes afterwards. So then there's dependent business interruption insurance. That is if a third-party provider to you causes an interruption in your system. And of course, some system failures, digital asset loss. Cybercrime, again, another area. If you are worried about business email compromise or a potential malware getting into your system through a phishing attack, you have to look at those carefully because they're separating out now. Typo squatting may not be considered a cybercrime. It may be considered something else. So you've got to very carefully look and walk through these scenarios you have in your organization to understand if it's actually going to be covered or not. And then there's reputational harm, which again, if you're L'Oreal or have a big personal brand, might be something that you want to cover. But if that'll depend on your marketing team and their organization. I guess the net of all of this is it's really complicated. And if you feel like this is an area that your organization needs and is not thinking about carefully, it's probably worth bringing it up right now. because policies are being reviewed and drafted. There tend to be, annual boundaries, annual contract boundaries. So right now is the time to bring this up and say, hey, I just went to this talk. And they talked about how things are changing like crazy in cybersecurity insurance. So maybe it's time to review our policies. Then just for fun, just so you can sound like an expert, you can say you can use some of the cyber insurance lingo. So we have all sorts of special languages, business insurance, CG&L, E&O, criminal acts and fidelity, commercial property, and then of course, cyber. And you're sitting there going, why, if there's a cyber insurance category, are we looking at all of these other areas of coverage? Well, because you might actually have some remedy under these more traditional standard clauses, even your commercial general liability. Like I said, a data publication to the dark web was considered a publication, and we had a client get recovery under a CG&L policy. So if you're informing or communicating with someone, just remind them to go through everything. So this is my checklist of things that I do when I actually try to review our tiny little company's cybersecurity policies. And we deal with financial data and information, so we do actually try to take this seriously. There are some important aspects of things like sublimits. And the new one that's come out that's relatively recent is new or should have known. So this is what's important for the actual practitioners. Because if you have an application risk or a compliance risk or internal tech debt that has identified a cybersecurity risk that ends up causing a breach or a liability in the future, your insurance company may have a new or should have known exclusion, and you may not get coverage for that. And this is kind of recent, but as we see more and more standardization, especially coming down from the federal government, I think it's important as practitioners that you be aware of this and be aware of, keeping your data and communication paths all the way up to the CFO or the finance person, whoever is in charge of this. Breach of contract exclusions. I really tried hard to wrap my head around this, but effectively it's saying that if your act would have caused you to breach a contract, if your act or omission would have caused you to breach a contract, then it's not an insurable event. So this means that you actually have to look at your obligations. This happens a lot in disclosure requirements, for data disclosure requirements. You have to go back and look at your obligations and make sure that it doesn't conflict with your insurance policy. This sounds like a lot of work, doesn't it? Who would really want to do this? Yeah, nobody. Fortunately, there's professionals out there who can do this for you. But the whole point of these kinds of checklists are to enable you to issue spot and identify and bring things up. It's impossible for any of us to actually solve these problems. We just need to make people aware and try to make them think about whether or not this is important for them. War exclusions. So you wouldn't think that would have anything to do with cybersecurity. However, the language that's being used now when we talk about some of these data breaches in terms of them being state actors, cyber terrorism, there is discussion that in fact cyber incidents may end up under the war exclusion in your insurance policy. So again, if you're at risk for being targeted from a state actor, then you probably need to look at that exclusion provision carefully and make sure it excludes cyber. Territory limitations, those are pretty straightforward. And then defense costs. Now, all of these clauses have, yeah, it's a lot of work. All of these clauses are going to have sublimits, deductibles, co-limits, and caps. And it's you almost have to make a Venn diagram and map them out and see and determine. And capping is, you have to be very careful across, because sometimes capping is only under a single category, and you need to know if the caps stack. If you have coverage potentially under 2 sections of your policy, if it's capped in A, is that a max cap, or is that a additive cap, or is it the aggregate of the max cap? It's very important to actually just build out, an Excel spreadsheet and tack this all up and add it up. My strategy, if you're ever asked to opine on one of these, is pretty straightforward and simple. I start at the exclusions. I write down every single exclusion, and then I try to map that back to the real world. Because of course the exclusions are written in insurance language. But mapping that back to what is the application risk, what is the compliance risk, what is the policy and procedure risk, that's where your knowledge of how things work is very important. Because lawyers can't draft that, and most importantly, these insurance policies are written by insurance lawyers. And remember, they all still work on mainframes. So you can take this from a policy, that if you ever get involved with it, that's the most important thing, that's where I start. The second thing that's important, and this is also where you and your teams are important for the organization, is you want to build your relationships up front. And right now is the time to do it. A lot of times when I get called in on a forensic situation, my hands are tied, because the insurance policy says you must use vendor A. If you have an existing relationship or a vendor that you like, you have to pre-negotiate it now to get it on an approved vendor list by your insurance company, or you won't be, or you'll have, it's not that you can't use them, it's that you'll have to pay for it yourself. And these relationships, especially if you're in an area of risk, any kind of financial data, health data, now energy, if you're in any of those sectors that are being targeted, you know how important it is to be able to work with people that you know and trust. So explaining to your CFO who those organizations are that you trust and getting them pre-approved in advance is critical. I actually had to help a friend to do this just recently. They had a ransomware attack through their cloud provider, and this is a large, very large organization. They had no plan. They didn't even know where to start on the vendor list. Fortunately, she had me. So we were able to come up with a quick vendor list and negotiate and get those contracts in place. But the challenge is, if you wait until the incident is happening, then you're making decisions in a rush. And we're going to talk about privilege and work product in a second, and I'll show you why it's so. This and figuring out your exclusions are the 2 most important takeaways from this meeting. Build those relationships in advance. Get them pre-approved by your insurance vendor. I don't know, we probably can skip this negotiating tips. It's a slide in there. You're probably not going to have to negotiate a cyber insurance policy. Feel free to give this to your CFO or your general counsel if you happen to have one. There is a lot of horse trading going on right now. I'll just give you what we're seeing is deductibles are doubling. So then the level, your threshold deductible, especially for ransomware, they're doubling for sure. If you've got a $2 million deductible today, it's probably going to be 4, and you're going to pay 2 to 3 times as much for it. That's how bad the ransomware business has been lately. Who knows how many average days your systems are down in ransomware? I got 21 to 23, but I'll give you 37. So here. I have way too much food in my house and I'm traveling, so it's coming here. Yeah, they're healthy, sort of. So if you're going to be down, or part of your system is going to be down during a ransomware attack for 21 to 37 days, what's your backup plan for that? And, you know, we've all, I mean, how many people here have ever actually done a backup? How many people have done a restore? Right, exactly. And if you're depending on your third-party provider, your SaaS provider to be your backup and restore person, they can show you all the log data that you want. Yeah, you went successfully. You know, that is worth the cost of the paper to print it when they can't actually restore it. It's also one of the biggest challenges with ransomware attacks is you have to do incremental restores, right? Because you got to figure out when the ransomware got into your system. They don't hit you the same day the malware shows up in your system. You've got to go back and find where it is on that restore. And then you've got to be able to do incremental data updates with avoiding the executables. And that's something that I'm lazy, honestly. My backup restore strategy is dump the whole drive. If you haven't done a tabletop and planned for an incremental restore, it's definitely something you should be talking to your IT teams about. Now we get into the fun legal stuff. All of that was preparation for the fun part of the talk. Handling an incident. So the very first thing that you have to do if you have a cyber incident is this is a legal thing, form something called a control group. If you don't form a control group, anything you say or do will come out. And control groups are very specifically defined. So control groups are a way of implementing the ability to state to a judge that you have privilege and work product. Privilege and work product are actually legislative or statutorily created rights. And they came out of an old English common law principle was that a wife could not testify against a husband. So when we talk about privileges, they really come up more out of the criminal law context, and they're very restricted in civil law. But they still do exist, so you have to be very, very careful, or you're going to break your privilege and your work product will become readily available. And in the cyberspace, especially in insurance, where we're mostly talking about forensic reports, the law is all over the map. So we have to go to the lowest common denominator if we're going to have any hope of trying to protect information that occurs during a cyber incident. The second thing that's really important is that a lot of policies have an exclusion that coverage does not start until they're notified. So you have to form your control group really quickly, which is typically going to be run by your attorney, your general counsel, if they're there, or your outside counsel who you're going to hire specifically for this incident. You're not going to go to your general outside counsel, your contracts person, or your compliance person, or your workforce, your HR lawyer. You're going to hire a specific, likely separate firm specifically for this incident. And then somebody has to know where the policy is, and somebody has to know who to call. And you would be shocked at how many times, especially if the policy's just been rolling over, nobody knows where it is and nobody knows who to call. So just like we have, when we have our call trees on our cyber incidents for internal communications, somebody needs to know where that insurance policy is and who to call. And then the vendor selection part of it. And again, I mentioned it earlier, it's really important to get those relationships, and it's October. If you have a favorite, get it to your CFO now. It's very important to discuss that. And sometimes your outside counsel can negotiate for you. Your outside counsel is going to have to hire the forensics person. This is the craziest thing. You don't get to hire your own forensics team, because that breaks the privilege rules, and it'll come out. And we'll go over a couple of cases and look at how the court thought about this. And then then there are terms and conditions around payout. And we're going to talk about ransomware, and we're going to talk about some of the exclusions that have arisen in ransomware, and why it's important to get that insurance company involved early, but to have them controlled and managed by outside counsel. So a control group is a limited number of individuals who are allowed to communicate under privilege. So privilege covers communications. Work product covers, in our situation, typically forensics reports and analysis, covers activities. The work product, you can all imagine, what's the work product every person who's about to sue you wants to get their hands on? Somebody say it, please. It's the internal. Yes, exactly. It's the internal forensics report. It's your IR report. And if you've started an IR investigation internally earlier with your own staff, that is not privileged. That's ordinary course business operations. So if you're on one of those teams, don't put your opinion in it. Do not write down your opinion. Just state the facts. Oh, this port was left open. Oh, this patch wasn't done. Oh, that credential was compromised. Just the facts. No opinions. Keep those to yourself or to your husband under attorney-client privilege. And if your husband's not an attorney, just keep it to yourself. Don't be offended if you're not in the control group. The control group has to be a very, very, very small number of people, and it has to be very, very limited. So it is very likely that you are not going to be in the control group. I get CISOs asking me, why am I not in the control group? Well, you're not an officer, and they don't want you in there. Probably also you know too much. So you're not going to be, none of us are going to be in the control group. So don't be offended. And then the other problem is sometimes your organization wants to get ahead of things and wants to get quickly going on. They want to start their mitigations and remediations, and they don't wait until they've had a demand or the anticipation of litigation has not yet arisen. It's and this actually turns out to be important into whether or not this outside forensics report with opinions can be covered under privilege. And the last thing is, it only works here. If your data breach is in Germany, sorry. If it's in China, well, forget it. Only the United States, but Canada, Mexico, there's no other legal framework that we know of that actually has this concept. So, it doesn't mean that it's not good practices and procedures to follow a policy around privileged communications and a control group, but just don't be upset if you get an international claimant and all of a sudden all your hard work goes for nothing. Okay, so it's an evolving framework. I'm going to give you 2 use cases and we'll play You Spot the Difference. And it does not protect facts. And again, that's why I said those early investigations, those early reports you do, just stick to the facts. So here's 2 recent cases. One of them is Capital One. We all remember when they had that, open S3 bucket. Why do people put unencrypted PII out there anywhere ever anymore? Come on, you guys are AppSec guys. Isn't it easy to tokenize or mask or am I dreaming? I always look at those vulnerabilities and go, how are we still doing those? How are we still having those? And then, really you left an open S3 bucket? Really? But anyways, Capital One did it with a whole bunch of mortgage applications where people, of course, gladly gave up, their bank account data, their social security numbers, their firstborn's child's name, and et cetera. But I think it was about 70 million records that were breached. They had 60 lawsuits filed in the first month. So what Capital One did is they hired a separate outside firm. The outside firm got a separate forensics company. They had a specific work scope. Here's another trap. If you already have a deal, if you're a Mandiant customer on a retainer, that ain't going to be privileged. Anything done or the end of that is not going to be work product. No. You have to have a separate one. and a special one. And it has to be written specifically for this incident, specifically in preparation for making decisions about litigation and litigation strategy. So they hired an outside specialist firm. The specialist firm hired a separate forensics company. They wrote a specific scope of work. They doc-signed and marked and tracked everyone who got a copy of the report. So they could show the judge, these are the only people who had this report. And so there were a couple of other factors as well. But effectively, the judge said, in that case, we agree. This is work product and prepared in advance of litigation. They went through a 10-step analysis. There's a really good Aiken and Gump article linked right there if you're interested in reading it. Now let's compare and contrast that with what happened to a law firm named Clark Hill, who has a practice in cybersecurity and breach notification and management. You would think, oh, no brainer, they're gonna get it all right. Well, you obviously can tell, I love poking fun at my own industry. Clark Hill failed to get their report covered for a couple of really important reasons. Number one, they did not create a unique scope and set of work, and they did not have it controlled. They did not control who got access to the report. Some law firms that I know now are so anxious about this, they don't even want these reports, they don't even want to receive the reports in writing. I'm occasionally asked to read the report over the phone or over Zoom, but not actually deliver a written report. They're the client, not my call. It makes my job a little bit harder. Fortunately, I like listening to myself talk. But it's, and we're in this highly variable, but can you imagine, my reports tend to be short, like under 10 pages. Can you imagine going through an actual IR report with a bunch of log data or audit data in it over the phone and reading all of that out? Again, facts are not protected, but the goal is to try to get the entire report covered. And that's by its nature, it's going to contain some facts. So Clark Hill, a law firm that specializes in cybersecurity data breach notification and services, failed to protect their forensics report as work product and privilege. The litigant got access to their report. And why are these reports so important, right? What is everybody hunting for? These are civil cases. So they're hunting for evidence of, correct. They're hunting for evidence of negligence, which is also a term of art. And in our industry, what are some of the factors that people are looking for at negligence? It goes back to that knew or should have known. Were you on notice? Did Microsoft have a bulletin out saying maybe you should patch the system? Did Oracle? Are you running a CVE program? Now, the number of times I have tried to explain to attorneys and judges that the failure to patch is not negligence per se. And I've done it until I'm blue in the face. I still don't know that people understand this. You cannot always patch, period. Every retail industry is already locked down on their IT now. You don't make a single IT change from now until the end of January. You don't change a port, you don't open up a new firewall, you don't change a configuration option in AWS or Azure. It's locked down. A critical patch comes out, you're probably not gonna do it. You might try, and you won't even put in a mitigation. You won't even throw up a WAF and try to protect it in line with a WAF. Why? When does retail make all their money? Right now. You got to be on and active. So there are absolutely perfectly valid reasons why you may never patch. So it's not, in my opinion, it's not negligence per se, but you have to try to explain that to someone, and that's where these reports come in, right? They're going to put on all of the rationale why what you did or did not do was not negligence per se, and not. So that is very, very artful crafting of analysis of the facts and crafting, and you don't want that in the hands of your opponent. Okay, ransomware. This is a big topic, and we're already getting a lot of litigation around it. Actually, very sadly, the first wrongful death due to ransomware litigation is going to trial next year. A hospital was undergoing a ransomware attack. They didn't have the automated monitoring for fetal heartbeat, and a baby, as often happens, it's more than you know, happens in pregnancy, cord wrapped, baby went into distress, it was missed. The claim is because the hospital was under a ransomware attack and they didn't have enough staff to do the individual level of monitoring, and that the individual wasn't told that the hospital was under a ransomware attack. I don't even know that the hospital knew at the time the incident occurred that there was a ransomware attack. So, but you know, this is getting more and more serious, right? We all know hospitals are targeted. You know, you read these horrible stories of the older nurses having to run around and explain how to hand chart vitals. Okay, everybody here could do that, right? Everybody here could like take a graph and put 3 points on it and trend it. It's a little bit mind-boggling to me that basic skills like how to plot and graph on a piece of paper is not taught anymore. So these are becoming very serious, and we're going to see, of course, when bad things happen, it's the American way to hold somebody else responsible. We're like the largest country in terms of hold somebody else responsible. So we're going to expect more of these. So if you're involved in one of these ransomware situations, you've got to think even more carefully than you do in, I hate to say it, in an ordinary, you know, like PCI DSS problem, but you're going to have to think a little bit more carefully. And there's a couple of other subtle differences associated with ransomware. You may want to have a separate policy for your ransomware. You absolutely need to get a lawyer who is knowledgeable about ransomware specifically involved. We have a pretty good one up in Dallas named Sean Toombs. You've got to get a lawyer involved because there are some new swizzles. So first of all, there's a case right now that's being argued, or maybe it'll settle, I don't know, where the insurance company said, because you paid the ransomware through Bitcoin, that was a voluntary payment. We aren't responsible for it. So how much does your, and you know, ransomware, you're completely down. You know, if it was me and I was ransomware, I'd go to my insurance company and say, look, I've got business interruption insurance and it's costing me, you know, $1 million a day. So, you know, you can either pay this $250,000 Bitcoin ransom, or you can pay me, you know, my $1 million a day. But you've got to have somebody who can go and make that argument and make sure you get it in writing and make sure you get what you're paying for. The second thing, and this is very new, is if you get a ransomware attack, and of course you should involve law enforcement and the FBI, but if you are, the FBI and law enforcement are going to say, don't pay it, right? They don't want to create they don't want to habituate clients to paying. They want to not pay. We just had a big discussion of this in my women's CISO group. You know, would you or would you not? The one gal who was a CISO was a former FBI agent. Of course, she was on the no pay side. But you know, it's a business decision. It's a business decision whether you make it or not. You need to control that decision. Don't let law enforcement push you around. They should be there to help, not to hurt. But if you do make a payment, and this is really hard, you have to go check the sanctions list. And that means you're going to need somebody who has deep intimate, because they're all done over cryptocurrency, right? You're going to have someone who has deep dark web, black web knowledge of where that Bitcoin wallet might actually reside. Because if that is going to a country or a person, everybody knows about the sanctions list, right? The OFAC list. It's public. You can go Google. You should go Google yourself. Make sure your name's not accidentally on there. If you make a payment to them, you may not only be denied coverage for it, you may face federal liability. And the European Union, I can't remember where I read this, but the European Union has also stated that they're creating their own no pay list, sanctions list. So if you're an international company, not only going to have to check the US, you're going to have to check with the EU, with Interpol. So this is rapidly evolving. Like, who would have thought we need to check the OFAC list on a Bitcoin wallet that we probably don't even know where it goes? But you do. You at least have to show that you attempted to follow the law. So this brings us back to my final slide, which is know before you go. The pre-preparation, just like you do in your regular incident planning, pre-preparation for dealing with your cyber insurance is a must. And unfortunately, because of the cyclical nature of cyber insurance, it's probably a must right now, because you're probably going through that analysis and negotiating with them right now. So we've got a little checklist here for you. Again, we're going to post these, right, Kate? We're posting the slides? Yeah. We're going to post the slides so you can take it. I've got some additional checklists in the notes sections. Hand it off, give the whole presentation to your CFO. My only request is you do not ask me to do anything. Because A, I'm not an expert in this area, and you really do need an expert. If you feel like you need an expert, I'm happy to make introductions, but I am not an expert in this area, and I'm not answering my emails right now either. But hopefully Tuesday through Thursday, I'll get a little break. Questions?
So I lied, we don't post these.
We don't?
The chapter meetings, we don't for last.
Oh, can I give it to someone? Being videotaped, yeah, but who wants to go sit in, everyone wants the deck, right? You guys want the deck? Yes, you do want, raise your hand if you would like a copy of the deck. Okay, we will figure out how to get a copy of the deck out. Yes, we can post it with the, whatever, if worst comes to worst, you can get it from me. Any other questions? Who wants to become a lawyer?
So this is so complicated. You're talking about self-insurance. That's the easiest way to do, because they're going to wiggle all over and not going to pay anything.
Right.
They make money.
Yeah, that's at the very beginning, self-insurance, and you may be into forced self-insurance, as I said earlier, because deductibles are doubling and premiums are quadrupling. So that's an internal business risk decision, and I think it's highly specific and highly individual, but absolutely, we talk about that all the time. Have I got a good enough compliance program? Do I have enough understanding of what my actual risk might be or my theoretical risk might be in order to self-insure? If you're a large company, like a lot of the larger companies, I know they do that, but if you're a small company and a single incident could take you down, and we know this happens, then figuring out at least, some reasonable amount of insurance, even if you're going to be paying, $50,000, $60,000 a year for it, figuring out some reasonable amount of insurance that'll at least let you get through this and try to reset is probably appropriate. So for small, medium businesses, I highly recommend getting some form of coverage. Otherwise, you're going to be calling me and trying to have me help you do some forensics reports so you can try to blame somebody else and get the money from them. You're one of your third-party providers. But that's a long haul, right? You've got to have enough staying power to make it through that entire process, which is going to be multi-year. It's just going to be multi-year. Unfortunately, it's the world we live in. It's predominantly out of our control. I do highly encourage you to think about self-insurance, but for small, medium businesses, I recommend, at least enough coverage to keep you running for a quarter. Yes, sir.
What are some major differences in what you present when it's applied to, say, nonprofit or states or mental entities?
State entities are usually self-insured. I don't even know if they can get commercial insurance for this. Maybe they can, some of the sub-state entities. Nonprofits, I believe there are some specific insurance companies that focus specifically on nonprofits, and they try to risk pool so they can offer lower premiums. And I apologize, I don't know about state entities. I don't know if they have, the state entity for sure, you should be able to, through the comptroller's office, get access to a preferred vendors list. If you can get insurance, I would definitely check with the comptroller.
Yeah, we've had used it before. You state, we buy insurance and we had to use it.
Yeah. Yeah, the ransomware as a service is, up and coming, and that means that everybody is a potential target, right? Because they can spray and play against a large number of domains and usernames. And and I'm still surprised at nobody in this room would ever share a password with their work environment and their personal environment. I'm shocked at how many organizations still don't have that as a requirement. And then even if they do list it in a policy, they don't actually go ask people, or they don't give them a tool like Keeper or LastPass to enable them to have strong passwords. It's still back to basics. So insurance is great, but remember, it's insurance. Make sure you're doing your basics first. Great. Well, thank you all. Anybody else? I have lots more kind bars if anybody else wants a kind bar. And again, if we can't figure out how to make this generally available through an email list or something through the conference, hit me up. If you don't have it by Monday, November 7th, hit me up on email and I'll email it to you directly. Along with lots of other fun reading if you're really interested. So indicate your level of interest, basic, medium, high, and I'll send you a pile of other stuff. Thanks.